mention a matter from the list serial number 44. This matter relates to the definition of workman. Leadership has already decided this issue that managers do not fall under the definition of workman, relying upon that Delhi High Court judgment. I was.
Orders with
You have informed the other side? You get that judgment and give it to us right now. वो judgment जो भी आप rely कर रहे हैं दे दीजिए, नहीं तो कल नहीं हो पाएगा.
Leadership daily 10
कल छुट्टी है परसों. परसों supplementary list बनेगा तो.
Leadership daily 10. I would like to see time. Reason being, senior counsel has daily 10 because senior counsel has Bhumi Pujan in his house. I have already informed the state.
The case will be adjourned only when the case is called.
From supplementary list for orders with effect item 1.
Outside list. परसों supplementary list में.
From supplementary list for orders with effect item 1, WPC 5115 of 2017.
देखिए WBC number 5115 of 2017. Nobody appears for the petition. इसका पहले स्टेटस पता कर लो. देखिए इसका टाइटल सूट नंबर 100 of 2005. कोर्ट ऑफ सिविल जज विद ब्रैकेट्स सीनियर डिवीजन ब्रैकेट क्लोज रोमन कोड देखकर पता लग जाएगा इसका स्टेटस. इसको पास होगा हो गया.
Item 2, WPC 5251 of 2017.
2017 में आपको 3 weeks टाइम चाहिए. Sorry? It is a defective petition. Is it defective? Defective है. क्या बोलना है आपको? क्या मैटर है? क्या मैटर है ये?
This case had become infructuous because the prayer which had been made, my lord,
Yes.
that become infructuous.
Then you withdraw it. WPC number 5251 of 2017. Counsel for the petitioner submits that the present petition has become infructuous and accordingly wants to withdraw the same. Counsel for the respondents? As no objection, अपना appearance ठीक से दे दीजिए. Has no objection to the prayer for withdrawal. Accordingly, this petition is dismissed as well.
साइन कर
Prayer code for them.
Item 3, WPC 6689 of 2019.
Leadership, the defect still exists with relates to the type copy, and page number 56, 64, 84, 85, 86 and 87 are the front page of stamp papers.
56,
64,
64,
84,
84,
85,
85,
86 and 87.
86 and 87.
These are all the front page of the stamp papers.
So,
that may be ignored and the rest are submitted. Rest type copy and translated copies are submitted.
What is this document? What is this document that you have filed?
So, I'm unaware.
And what is the matter? There was already a pre-entry order in 2022. Yes. Why this case has not been dismissed for default? Stood rejected on 25/2/22. Memo couldn't be issued. It is already a dismissed. It is a dismissed writ petition. दिखाइए इनको तो रिकॉर्ड भी देखने का टाइम नहीं शो इट पास ओवर.
Item 4, WPC 1308 of 2021.
Petitioner. Where is the petitioner? WPC 1308 of 21. Nobody appears on behalf of the petitioner. The matter has remained defective. For a long time. However, time till ninth of December is granted to the petitioner to remove the surviving defects plainly. If the defects are removed within time, holds this case on 12th of December in the Supreme Court list. Give your appearance, respondent. It's a dismissed case.
This was restored. This case was restored by CMP number 192 of 2022, audited 9th of May 2024.
Alright. Now it has remained defective.
Let's say there are defects with regard to type copy. We have already filed all the type copies except for page number 56, 64, 84, 85, 86 and 87, and that needs to be ignored also. Like page number 56, all these defects leadership, they are regards to the front page of the stamp paper which cannot be provided by the type copy.
The stamp paper is regarding what?
The copying department, stamp of copying department.
You are seeking a direction for registration.
Yes, for
You deposit the original before this court.
Sorry.
You submit the
Original
original
copies.
before the learned registrar. We need to see, no?
Yes, yes.
When we have to give a direction for registration. Just tell us one thing.
Yes,
He must have passed an order.
that has been challenged. He has rejected the
Okay. This is 24/9/2019.
2019.
What is the page number?
135.
Yes, read it please.
श्री नूरुल हुदा वल एनुल शेख ग्राम भट्टिया पोस्ट सचिन सच के द्वारा मौजा भट्टिया थाना संख्या 282 के खाता संख्या 159 लगभग 0.14 एकड़ भूमि के निबंधन हेतु दस्तावेज प्रस्तुत किया गया। प्रस्तुत दस्तावेज के आलोक में प्रश्नगत भूमि की जांच अपर समाहर्ता गढ़वा के पत्रांक 119 दिनांक 17/1/19 से प्राप्त प्रतिबंधित गैर मौजूदा भूमि की सूची से किया गया है। पाया गया कि प्रश्नगत भूमि गैर मौजूदा खाते की प्रतिबंधित भूमि है। आवेदक प्रस्तुतकर्ता से भूमि की गैर मौजूदा नहीं होने से संबंधित कागजात प्रस्तुत करने को कहा गया, किंतु उनके द्वारा ऐसे कोई कागजात
You have an appeal against this. This is an appealable order. You avail your appeal. Under the Registration Act, this is an appealable order. You avail the remedy of appeal. Correct?
Only it will be posted tomorrow. I will take instructions.
Why you don't need to take instructions? It is an appealable order.
The order will pass later and delay may be found.
We will not condone the delay. The matter has remained pending since 2019. We will not say anything more. We will just say that case number itself is sufficient. Isn't it?
But वहाँ दिक्कत
क्या दिक्कत की कोई बात ही नहीं है. मैटर यहाँ पेंडिंग है. 2019 से यहाँ मैटर पेंडिंग है. Right. WPC number 6689 of 2019. The learned counsel for the parties are present. Counsel for the petitioner has submitted that there are certain ये क्या है? Certified original copy of annexure 8 may be given with authentication fee. अच्छा ठीक, कोई बात. The learned counsel for the district petition has been filed for the following relief. The learned counsel for the respondents has submitted that the district sub-registrar Garhwa has passed an order refusing to register the property. He submits that the said order is an appealable. कौन सा section में है? Registration Act. The petitioner may avail the alternative remedy of appeal. Under section 72 of the Registration Act. Considering the aforesaid submissions, this court is of the view that petitioner has efficacious remedy of appeal against the impugned order. Accordingly, this court is not inclined to entertain this petition. This petition is accordingly disposed of. Liberty is reserved with the petitioner to avail the alternative remedy of appeal within a period of 30 days. 30 days उसमें already है.
Item 5 WPC 1311 of 2021.
Petitioner.
because the petitioner has died and he has paid for the absence of providing the medicine for thalassemia, hepatitis C.
Petitioner has died. WPC number 1311 of 2021. Nobody appears on behalf of the petitioner. This petition has been filed for the following reason. The learned counsel for the respondents has submitted that the petitioner was seeking mandamus to provide medicines so that he could be treated, but the petitioner has already expired. You have stated so in your contract.
Para 11 of page 11 of counter affidavit.
This fact has been brought on record through the counter affidavit that the petitioner expired on 27/3/2020. Shortly, in view of the aforesaid circumstances, this petition has become infructuous for all practical purposes, disposed of as such. और कोई पैसा वैसा तो नहीं मांग रहे थे?
Item 6, WPC 1334 of 2021.
Petitioner? What is it about?
Encroachment matter, Durwa type का.
Challenging the notice, public notice. और भी तो केस हुआ होगा
और भी केस हुआ है.
क्या हुआ सब?
The report has been asked by the circle officer from the district land acquisition officer of the district land acquisition office whether those plots have been acquired or not. This is off the record not because
yes.
Yes, I am saying. I will file counter on this.
Defective petition and defective में क्या ही काम करता है? Counter already filed है.
Right.
कहाँ है इसका काउंटर? केप्ट ऑन रिकॉर्ड में. इसमें लिखा है C on behalf of respondent number 325 dated 19/8/21 is kept on record. बुलाइए, पता करें, पास ओवर कर.
Item 7, WPC 1372 of 2021.
Yes, petition. Any counter file? What is your stand in the counter? No, the certificate proceeding has been initiated. Did he file any objection? did he rush to the court? What is this case?
As per the annexation last paragraph, the conclude
So 2 weeks time to be given.
No. In practice cases, 2 weeks time needed. Why have you come here? Go and file your objection. Is it pending?
This case, let's see, Mr. Amar Kumar Sinha.
वो है आ गए
इसमें कुछ डिफेक्ट्स हैं।
कोई डिफेक्ट का बात मत करिए
Item
इग्नोर
7.
Very
Item 6 है.
6 है. Oh, sorry.
6 pass over हुआ.
I'm sorry.
अभी होगा तो आप हैं इसमें
Item 7 WBC 1372 of 2021.
एक ऑर्डर किए थे ना हम लोग प्रेमटी टाइम वाला सेम पिटिशनर एब्सेंट स्टेटस आप एक पता कर लेंगे इनमें रीड है कि क्या हुआ सर्टिफिकेट प्रोसीडिंग में
Item 8 WBC 1386 of 2021.
Prayer has been made for portion of the entire certificate proceeding and the notices. Objection has not been filed by the petitioner and he has been absconding ever since after the issuance of warrant of arrest. We filed the counter which we have stated about.
The same preemptive order वाला petitioner absent you give your appearance
Yes.
Item 9 WBC 1400 of 2021.
and you need to also communicate to the concerned certificate officer.
Same matter related to passing of the certificate case.
Petitioner absent and same order. It is still defective. Pankaj ji, जिसके भी certificate proceedings है ना, उसमें लिखिए that let this order be immediately communicated to the concerned certificate officer and also to the deputy commissioner of the district.
Item 10 WBC 3856 of 2021.
Regarding to dispose the appeal of the petitioner pending before the deputy commissioner regarding cancellation of the mediation license.
That is the only thing. This petition is defective. The appeal must have been disposed of by now, isn't it? Okay.
I need to seek instruction.
You don't need to seek instruction. It's a defective petition. वो defective वाला scene होता है. You give your appearance.
Yeah.
Item 11.
Supplementary.
Item 11 WBC 3857 of 2021.
This case is still defective.
So what is the relief? Forget about the defect. What is the relief you are seeking?
Regarding the cancellation of PDS license, I'm not well acquainted with this case.
And why are you appearing? You are not aware about this case. Since 2021, the matter is defective.
1 week time maybe.
For what?
So I can come and prepare and
Yes, respondent. What is the prayer?
Lord's, it's against the private respondent number 8.
You read the prayer. What have you? What? There is a prayer that you should take action against respondent number 8, who is giving lesser quantity of wheat. तो बहुत अच्छा prayer है. क्या किया? This is well known to the entire state of Jharkhand. But for the first time, such prayer has been made in this. What have you done? What action have you taken? Did you make any inquiry? Inquiry is in favor of respondent number 8. Where is the report? Report चाहिए report if you have done some inquiry. Right? बहुत serious बात है. उतना ही seriously लेंगे आप इसको. Thereafter, an order has been passed by Food Commission Ranchi. Where is the order? A case was registered. Where is the order? You should annex the order and the proceedings.
We will file supplementary contract in which we will annex the order.
Okay. WPC number 3857 of 2020. Counsel for the parties are present. This writ petition has been filed for the following relief. Counsel for the respondents has submitted that a counter affidavit has been filed referring to report of referring to inquiry report and also certain order passed by Food Commission Ranchi stating that Food Commission here तो लिखे हैं Ranchi page 18. Stating that the grievance of the petitioner was registered as RA-AA-AA case number 10 of 2020, and in spite of repeated opportunities, the petitioner did not participate in the proceedings and an order has been passed. However, the counter affidavit is not supported by any document. Counsel for the state is directed to seek instruction and file a supplementary counter affidavit bringing on record all the documents and proceedings which have been referred to in the contempt date. The need to be done by 3rd of December 24.
थोड़ा सा
10th of December 24. 10th of December 24. Post on 11th of December in the supplementary cause list. In the meantime, the petitioner shall remove the surviving clauses. You remove it, don't keep it. इसको defective रहेगा ना तो भी इसमें ऑर्डर करेंगे. आप इसको रिमूव करिए सारे चीज़. खास तौर पे अगर कोई कोर्ट फीस वगैरह का डिफेक्ट हो तो कर देंगे.
Item 12, WPC 388 of 2021.
Lordship, 2 weeks time may be ending.
What is the matter?
Your Lordship, actually the learned counsel are hearing this case, Learned Vijay Shankar Prasad, there is no more. So
There are other advocates also.
yes.
This order passed in the mutation proceeding is an appealable order. It's unfileable. Isn't it? Your advocate on record?
No, no.
Under
I am
whose instructions are you adhering?
I am instruction of Vijay Shankar.
He is the advocate on record. WPC number 3888 of 2021. Counsel for the petitioner is present. Considering the nature of defect number 3, the same is ignored for the present. अब बाकी जो प्रेमरी टाइम है you see the remaining defect, otherwise DFD होता है. Otherwise it's an appealable order.
Item 13, WPC 3895 of 2021.
Petitioner. इनको notice quash कराना. Why is he agreed?
Respondent number 5 has filed the objection. Your Lordship, earlier case was initiated.
If a notice has been issued, they have to respond. So,
The disputed case, Your Lordship. Only on notice they have come before the court.
they say that in the title suit, the matter has been settled. Execution pays title suit.
Order.
he appears on behalf of the petitioner. Rajesh Bhushan, do you know him? Counsel for the state is present. Post after tomorrow in the afternoon.
Item 14, WPC 4231 of 2021.
In this case, after 13 years, the notice has been issued in settlement case, section 89 of the
It's a defective petition.
similar order.
Petition is defective.
I will remove.
What similar order has been passed?
Yes.
कहाँ से?
Large number of cases filed, but out of them, 3 cases translated copy and NSR 1. Take all the points and
उनको दिखाएं same matter.
My lord, there are the private respondents from respondent number 6 to 11 years.
क्यों नोटिस करें? इसलिए नोटिस करें। ये अपना जो भी होगा अपना रेस करेंगे।
My lord, I just this information is brought before your lordship. So that.
What?
My lord, in this present treat application, your lordship, there are private respondents. Starting from serial number
आपने
6.
ये ऑर्डर देखा है?
My lord, here is not sir.
तो फिर आप बिना ऑर्डर देखे क्या ही बोल रहे हैं? ठीक है? Same order? Like
all 3 cases, 14, 15, 16, same.
14,
15 and 16. Serial.
नहीं तीनों फाइल। डिफेक्ट में क्या है आपका? 40 में डिफेक्ट नहीं है ना?
Translated copy हुकुम में।
40 का डिफेक्ट में ऑर्डर नहीं कर सकते। काउंटर एफिडेविट में क्या है इनका? What have they stated in the
काउंटर एफिडेविट के पेपर नोटिफिकेशन हुआ। पेपर में पहले बताया थे
कब हुआ था notification?
पेपर में जनरल नोटिस
My lord, and accepted at page number 14. There was the general notice with regard to process provision under section 89 of the CNT Act, Your Lordship, inviting me
But all these matters can be taken care of by the authority. आपको तो notice ही हुआ है ना? You are
नोटिस पर्सनल नोटिस नहीं हुआ, ये जनरल नोटिस हुआ,
general notice. ठीक है,
ये
जो भी
आफ्टर 12 years.
whatever be the period, they will consider everything. देखिए,
below the Annexure 7 of the writ petition is under challenge, Your Lordship. This is the notice.
that's right. 15(9) same ही है notice है ना? Learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that under similar circumstances, the writ petition being WPC number 4336 of 2021 has been disposed of without interfering with the impugned notice dated 15/9/21 and giving liberty to the petitioners to raise all available points before the respondent number 2 in the concerned revision case. In the said case, the concerned revision case was revision case number 1433 of 2020. He submits that in WPC number 4231 of 2021, the concerned revision case is 1431 of 2020. In WPC number 4253 of 2021, the concerned revision cases 1432 of 2020. In WPC number 4251 of 2021, the concerned revision cases 1430 of 2020. He submits that similar order may be passed. The learned counsel for the state has submitted that the required procedure has been followed and there is no illegality. Okay. After hearing the learned counsel for, however, he submits that the case can be disposed of in the same terms as order dated 2/3/22 in WPC number 4336 of 2020. After hearing the learned counsel for the parties and this court finds that the petitioners have challenged the notice issued to them by respondent number 2 in limitation matter subsequent to filing of an application under section 89 of Tobacco Tenancy Act. According to the petitioners, filing of revision by private respondents before respondent number 2 by passing other statutory provisions, that too after long 14 years from the entries made in the draft record of rights, is not maintainable. This court is of the view that the aforesaid aspect of the matter can be raised by the petitioners in the pending case before respondent number 2. Hence, without interfering with the impugned notice dated 15/9/2021, these writ petitions are disposed of, giving liberty to the petitioners to raise all the available points before respondent number 2 in the concerned revision case as indicated. petitions are accordingly disposed
Also for defect.
कोई बात नहीं डिफेक्ट क्या चीज है
Appearance. Item 17 WPL 1787 of 2024.
Husband of the respondent was an employee of BCCL. After entering 14 years,
this is a defective petition
there are two defects in the
why have you not removed the defects
Which annexure 5, they say I have wrongly stated that it is a certified copy, it's a true copy. So the correction has to be made, it is a true copy.
or what else
And the other defect is in the wakalatnama, the project officer has to be added. The clerk has not correctly addressed.
what is your case
The husband of the
no what is the nature of the appellate order
he has modified the order passed by the controlling. The
Say
controlling
what?
authority says that BCCL has correctly paid the amount of 3 lakhs. However, the husband of the respondent is entitled to more amount, so BCCL can claim it from LIC. There is an MOU between BCCL and LIC that the whole period will be counted. So we were not agreed by the orders passed by the controlling authority. Now the appellate authority modifies it and says BCCL to me. Although the MOU
so
says
the entire issue is who would take this
either the LIC, BCCL would not be liable. We have to make a claim and LIC will make. That is the MOU. That is annexure 2 money.
so where is the LIC is not a party
No, LIC
Then-
was not a party there also.
LIC you have to make LIC is not a party and the appellate authority has fastened the liability upon LIC
No. The appellate authority says you make the payment. On
and you
BCCL.
realize it from LIC
That is the order passed by the controlling authority.
so appellate authority says that LIC is not liable
Not liable.
if you want some
Kindly see page 30 minutes for a moment. Page number 30. The order passed by the controlling authority.
can the controlling authority pass an order in absence of LIC
No. The controlling
are they
LIC.
not supposed to hear LIC
Whereas the controlling authority says that as per the payment of gratuity act, BCCL is liable to make payment of rupees 3 lakhs and odd, and that has correctly been paid by BCCL. So far as the other amount is concerned, BCCL should make a claim before the LIC, and LIC would reimburse it.
other amount is apart from gratuity what other
Apart
amount?
from the gratuity, there is an annexure 2, is a group
This
gratuity.
payment of gratuity authorities under the Payment of Gratuity Act will take care only of payment of gratuity.
In fact, that is my case. That
How are they concerned with other liabilities?
they cannot do it. The controlling authority and the appellate authority cannot enter outside the purview of the payment.
You
of
have not made the authority also party. Controlling authority ought to have been made party in this case. At least we should hear them. You don't make them party. Why? You should make them party. No? After all, they are the adjudicating authorities. If not the appellate, if not the appellate authority, then at least
In fact, in some matters we have made them parties. They appear and say, we are not required to defend our orders.
even the controlling authority.
There is a judgment of the Supreme Court on this issue that the authorities under this Act are not required to defend their orders before the High Court of the
So your entire grievances that so far as gratuity is concerned, that stands fully satisfied.
And they could
The
not.
authority had no jurisdiction to
To
pass
enter.
any order in connection with any other
Yes,
amount.
that
This is your case?
Yes.
I take it
Yes,
as it is?
yes, that is the ground.
And what about the defects?
I will remove in course of the
WPL number 1787 of 2020. Council further petition submits that. So far as defect number 1 is concerned, a true copy as forwarded by the concerned authority has been filed and it is not a certified copy. and he may be permitted to make necessary corrections in the main petition. And so far as the defect number 2 is concerned, he shall remove the same during the course of the counsel for the petition is permitted to remove the defects during the course of the and is permitted to carry out the necessary corrections. So we are looking at the grievance of the petitioner is that the authority under the Payment of Gratuity Act, having recorded that the entire amount of gratuity being paid had no further jurisdiction to ask the petitioner to make payment under any other head or other dues. आपका तो ये पैरा 1 में appellate order में लिखा हुआ difference of gratuity amount of rupees.
The difference would come from that with LIC. Kindly see page 30, it will be clear.
Anyways, issue notice to the sole respondent through the concerned police station, for which requisites be filed by day after tomorrow. In addition, notice is also issued through ordinary process. दोनों का requisite file.
Registered plus ordinary.
Ordinary process and through the concerned police station. Yes, speed post.
Speed post.
Yes, speed post and the concerned police station. दो set requisite आपको file.
I will file before the court 2 sets, one for speed post and other for ordinary.
The other will go through the concerned police station.
But I have to file 2 sets.
Yeah. Post on 10th December. Office to track speed post delivery and prepare appropriate office note.
Okay.
With regard to service of notice. Awaiting service report.
Passover case, item 1, WPC 51115 of 2017.
इसमें ना पूरा नाम कंप्लीट कर दिया ये क्या चीज़ है
Status one,
क्या सिचुएशन है
yeah.
पेंडिंग WPC number 5115 of 2017. Nobody appears on behalf of the petitioner. The petition is still defective. considering the fact that the writ petition is defective, time till November is granted to the petitioner to remove the surviving defects. If the defects are removed within time, closed on 3rd of December.
Consular case item 6, WPC 1334 of 2021.
गलती से लिखा गया इसमें काउंटर एफिडेविट के बारे में आपने लिखा है किस केस का लिखा गया ऐसे कैसे लिखते हैं आपने लिखा है कि किसी और ने लिखा सिग्नेचर आपका कहाँ से देख के लिखे हैं इसको अब पिटिशनर कहाँ चले गए बताए थे दौड़ दौड़ मिस्टर रमन कुमार Would you appease for the petitioner? It has been reported by the learned courtmaster after making inquiry from the office of this court that it has been wrongly mentioned in the office note that counter affidavit on behalf of respondent number 3 to 5 dated 19/8/2021 is kept on record. He submits that in fact no counter affidavit has been filed. Correct? उनका नाम बताइए उनका नाम लिख दीजिए ऑर्डर में दीपक कुमार गुप्ता ठीक है कंसर्न्ड officer in the section. He is permitted to make Mr. Deepak Kumar Gupta is permitted to make necessary correction in the office note. आप कर देंगे अभी? The petition continues to be defective. Time till December 6th is granted to the petitioners to remove the surviving defects framed. If the defects are removed within time, post on 11th. 6 December. दूसरे केस में 9 December. इसमें भी 9 December. If the defects are removed within time, post on 11th. 11th का डेट भी है सर 12 तारीख. ठीक है? 9 और 12.
Orders, item 18, WPC 4309 of 2014.
Against the order
क्या हुआ आप लोग
a substitution has been filed.
Sorry, substitution has been filed.
Wife and one son and daughter.
कहाँ है आइए
आइए कुछ कर लो.
घाट को नहीं गया था ये आइए अभी लगाए ना 14 तारीख का फाइलिंग है ना कल लग के जाना चाहिए था ना कौन है ये जो इस तरह से बात नहीं मानते WPC सेक्शन है ना, उनके जो भी इंचार्ज हैं उनको भी हाँ डिटेल लीगल हेयर्स का बताएंगे. डेथ कब हुआ है?
13/8/80.
लीगल हेयर का डिटेल बताएंगे.
Leaving behind his wife and one son and daughter.
तीनों का वकालतनामा है.
Yes.
Okay, IA number 12262 of 2024 in WPC number 4309 of 2014. Counsel for the petitioner submits that the petition seeking substitution has been filed on account of death of the sole proprietor of the petitioner, who expired on 13/8/2018. A copy of the death certificate has been annexed as Annexure 1 to the interlocutory application. The details of legal hears have been mentioned in paragraph 4 of the interlocutory application. Counsel for the respondents has no serious objection to the prayer for substitution. Accordingly, IA number 12262 of 2024 is hereby allowed. Counsel for the petitioner is directed to make necessary corrections and necessary insertions in the cause title in writing during the course of the hearing. This HCI का कहानी है इसमें.
State Warehousing Corporation for storing of the food grains, and in case the Honorable Court is inclined to pass an order for removal, we will remove the food grains and only 6 months time may be granted so that.
आपको कोई objection?
मेरा ऑब्जेक्शन यही है
पहले तो इनको हटाने की बात करो. They are nobody so far as you are concerned.
मतलब हमको जो इंस्ट्रक्शन है उसमें है कि ऑलरेडी बंद है वहाँ पर कुछ कोई स्टोर गोदाम अभी आज के डेट में है नहीं. सीबीआई भी गए थे जांच करने तो उस समय ताला तोड़ करके गए थे. कुछ नहीं हमको जो इंस्ट्रक्शन है बाकी
ये आपने काउंटर एफिडेविट कब फाइल किया?
This complaint was filed on was filed on 10th of April 2020.
10/4/23.
10/4/20. कुछ भी होगा तो हम लोग वहाँ से रिमूव कर लेंगे. अगर कुछ भी whatever जो भी फूड ग्रेन्स होगा या कुछ भी अपना
and then you will have no right there.
हम लोग का ना पैरा 6, 7 और 8 जो काउंटर का है उसको मेरे सबमिशन में लिखा है. काउंटर फाइल 10/4/20.
इनका आईए नहीं आया था ना, तो हम इस फाइल को ठीक से पढ़ेंगे क्योंकि सोचे आईए फाइल करेंगे लोग कब करेंगे. इसको कल रखेंगे, परसों रखेंगे. ठीक है, आपको भी सुनेंगे. आपका बाकी आप तैयार हैं केस फाइल आर्गुमेंट के लिए? तो लिस्ट ऑफ डेट्स वगैरह बनाए हैं? बना के नहीं देंगे तो कैसे हम ऑर्डर करें?
डे आफ्टर टुमारो रख दीजिए. डेट वाइज लिस्ट ऑफ डेट्स बना दीजिए.
डे आफ्टर टुमारो नहीं रखेंगे, फिर उसके बाद वाले दिन रखेंगे. आपको जो भी देना है आप डे आफ्टर टुमारो देना. ठीक है, आपको भी जो देना है. द लर्नड काउंसिल फॉर द पार्टीज नहीं पोज दिस केस फॉर फाइनल डिस्पोजल. Friday को नहीं हो पाएगा. On Monday. Okay, on Monday. In the meantime, parties to submit their list of days, short synopsis of arguments VCC and judgments VCC to rely.
Possible Tuesday अगर.
Tuesday, supplementary list Tuesday. ठीक है. The deed will be done by Friday. Friday तक आप जमा कर देंगे. Soft copy भी provide कर देंगे. जो भी आपके पास sequence of events वगैरह है.
ठीक है.
आपको तो कुछ करने का जरूरत नहीं.
इनका हम काउंटर का रिप्लाई भी दिए हुए इसलिए कोई दिक्कत नहीं है. सब दिया हुआ है.
आपको ऑब्जेक्शन है क्या? खाली कर देंगे. खाली करने पे भी होगा.
नहीं खाली का नहीं. जो इंस्ट्रक्शन जो हमको जो मिला है हम लोग एफिडेविट फाइल किए कि वहाँ कुछ है ही नहीं, उसके बारे में हम लोग दिए हुए एफिडेविट. वहाँ कुछ एक्चुअल में अभी एट प्रेजेंट जो है गोदाम कुछ नहीं है, बंद है.
तो फिर इनका ये सबमिशन भी खाली कर देंगे इज यूजलेस.
नेचुरल है. हम इनका रिप्लाई दिए, उसका कोई जवाब नहीं दिए कि हाँ हम डिनाई नहीं किए कि हम जो बोल रहे हैं वो गलत है.
If he is raising such type of submission on the last date, he is also he had raised such type of submission, then we will be permitted to file supplementary counter in this matter.
How
अगर
much
ऐसे
time will
oppose
you
कर
need
रहे हैं,
then?
तो 4 weeks तक.
4 weeks.
अब इस टाइप का एलिगेशन लगा रहे हैं तो हमको भी तो डिपार्टमेंट को बोलना पड़ेगा ना, वहाँ स्पॉट इंस्पेक्शन कराना पड़ेगा. बोल रहे हैं कि झाड़ी हो गया, ये हो गया, तो हमको डिपार्टमेंट को बोलना पड़ेगा. और स्टेट है, स्टेट तो टाइम लेगी ही लेगी. लेट होगा उसमें तो 4 weeks चाहिए उसमें.
आपकी मर्जी. तो ये इसके पीछे क्या झगड़ा है समझ नहीं आ रहा. आप बोलते हैं कुछ नहीं है, वो बोलते हैं जो भी कुछ है हम हटा लेंगे, फिर भी आपको परेशान.
हम एट प्रेजेंट जो है स्टेटस हम एफिडेविट में फाइल कर दिए हैं.
डीलरशिप हम भी अपना काउंटर एफिडेविट
आप अपना एफिडेविट फाइल करिए. Whether you have removed, not removed.
एट प्रेजेंट वहाँ रखे हैं कि नहीं रखे हैं वो एफिडेविट में बता.
सेकंड वीक ऑफ दिसंबर
ये सबमिट
Post on 10th of December.
इनका विलॉट बियाडा का लास्ट टाइम में बिफोर दिस ऑनरेबल कोर्ट सबमिशन था ही नहीं का कि बैग हमारा डिफरेंट फुटिंग पे अदर केस से है, क्योंकि मेरा बैग
वो
हटाया
बात
नहीं
का
गया.
बात.
और आज
10
बोल रहे
तारीख
हैं
को
कि
सुनिए. आपको जो एफिडेविट फाइल करना है ना पहले ही करिए.
जी सब
Unnecessary, it doesn't look nice. Food Corporation of India and these two authorities fighting, it doesn't look nice.
तो वो पीडीएस अन्नपूर्णा योजना के तहत जो खाना
आपको तो फिर बहुत अच्छा है बोलना कि हम तो ऑलरेडी खाली कर चुके हैं, बात खत्म हो जाएगा. इतना ही खाली बोल दीजिएगा हम खाली कर चुके हैं. आई हैव नथिंग टू डू.
ऐसी कोई चीज जो एफिडेविट में ला सकते.
ऐसी चीज को ला दीजिए एफिडेविट. स्टोरी वुड बी ओवर दैट यू हैव ऑलरेडी evicted.
Item 20 WPC 1773 of 2020. Along with item 21 and 23.
Compliance of the last order petition to
Mediation हो गया?
but the report is still undated and it has been informed from the other side that the report needs to be placed before the board of directors.
Mediation is successful.
Your Lordship, hearing has been done by the CMT, Your Lordship. It has been concluded and it will be placed before Board of
Okay,
Directors.
so you are not aware.
Yes, Your Lord. It will be placed before Board of Directors for final decision, Your Lordship. So further 2-3 weeks time.
WPC number 1773 of 2020, counsel for the parties are present. It has been reported by the parties that hearing has already been concluded so far as the point of mediation is concerned. The report is to be placed before the board of directors. The learned counsel for the respondents has submitted that the final outcome will be placed on record and the matter be adjourned. Post on 17th of December. The supplementary affidavit with regard to final outcome of mediation be filed by the respondents by 13th of December. 16th of December.
Item 24, Contempt Civil 796 of 1924.
Show cause was not accepted. We had
You have
taken
deposited the amount, done?
We have given the amount.
Contempt civil, the matter is pending in LPA?
They have covered an amount.
You have also preferred LPA?
Yes.
They have challenged the final order passed by
Contempt civil
There is
796
some
of
amount which
2020.
has remained unpaid under 17B, that particulars has been given in the show cause.
Not in this.
Some amount is still due which they
Yes.
under 17.
That issue was never raised at the time of deciding.
Contempt Civil 796 of 2024. Counsel for the parties are present. Counsel for the petition submits that the petition has no surviving grievance as the amount has already been deposited. Show cause has been filed on behalf of the opposite party, which is taken on record. Considering the submissions of the petitioner, this court is not inclined to proceed any further in this proceedings, which is hereby closed. So record it.
From ready list for final disposal item 1, WPL 1771 of 2009.
Yes, petitioner.
Last date was the Excel was one.
I think
If you were not assisting
we passed it. So,
Item 2, WPC 2381 of 2021.
It was short parcel, Mr. E.K. Sanani is report over 50 million
what is the matter?
I think in that related matter for a school, it's a construction of a school in a realty land of 50.8 acres.
Okay, pass on.
Item 3, WPC 2954 of 2021 along with item 4.
Yes, petitioner.
Yes, or not? Also, for the call by in WPC number 660294, I kindly refer this matter before
Before the
tribunal, Your Honor.
there are two cases.
In second one, your lordship finally permitted to withdraw.
Which one? WPC number?
WPC number 3048.
WPC number 3048/2021.
In this regard, your lordship, I hear.
Learning Counsel for the petitioner files interlocutory application before this court seeking permission to withdraw WPC number 3048. 8 की जगह 0 ही दिख रहा है इसको ठीक करने से 3048 of 2021. He submits that a title suit number 19 of 2024 is pending before learned civil judge senior division number 1 Bangalore. Any objection?
I'm not the party to that.
I am not intervening.
You have any objection for withdrawal?
No.
Learned counsel for the intervener and the learned counsel for the state have no objection to the prayer for withdrawal. Prayer quote कर देंगे इसमें ना एक petition. Accordingly, this application is dismissed as withdrawn. Considering the pendency of the title suit, right? Yes, considering the pendency of the title suit, dismiss as withdrawn. Withdrawal of this case will have no bearing in the title suit. ये वाला, other one. WPC number 2954 of 2021. The learned counsel for the parties are present. This petition has been filed for the following relief. Learned counsel for the respondents has submitted that the petitioner that considering the nature of relief prayed for in this writ petition, the petitioner has appropriate remedy under the provisions of section 14 of whole bearing areas within bracket acquisition and development bracket close Act 1957. And the claim of the petitioner may not be adjudicated under writ jurisdiction, which are disputed claims. She has submitted that multiple persons are claiming right, title, interest, etc. in connection with the property involved in the present case.
And even the state is claiming against this.
Even the state, the intervener, and others are claiming their rights. Considering the aforesaid submissions and the fact that there are serious disputes involved in the present case, which cannot be adjudicated under writ jurisdiction, this court is not inclined to proceed any further in this writ petition. Accordingly, this writ petition is disposed of, enabling the petitioner or any of the parties to approach the tribunal constituted under the provisions of the aforesaid Act of 1957. All the contentions of the parties are kept open. That should be sufficient.
No, only writ petition is being dismissed here because none of the prayers are being entered in, only the liberty is being given.
That's right.
Disposable, I say, just 1 minute.
Impossible, a lot of time has been.
We can't really give a time, but it is expected, I think so, that all the parties will be heard. ऐसा नहीं कि फिर आप किसी को छोड़ दीजिएगा.
Expeditious disposal.
Considering the fact that the matter has remained pending before this court since 2021, and acquisition is an old one, it is expected that the tribunal will take appropriate steps for expeditious disposal of the matter. It is also expected that one or the other party may choose. Pending interlocutory application if any is closed, interim order if any is vacated.
साइन कर दीजिए withdrawal इसको.
ये डाल दीजिए बस.
For admission, item 5, WPC 22 of 2012.
Apologies, may I say, claim that it may be taken up on 21st. Mr. Rohit Roy is appearing his birthday is not
The PC number double 22 or 2012. Counsel for the petitioner submits that the mother of our great counsel, Mr. Rohit Roy, is not well. And accordingly, he seeks adjournment. At his request, pose this matter on 21st. Give your appearances.
Item 6, WPC 746 of 2019.
Last occasion, raised certain queries regarding some dates. Last order may be seen. Mr. Sanjay had appeared on the last order. The query was as to when was the first petition for fixation of rate was filed. The receipt date is first petition was filed on 28/3/2003, and the impugned order was passed on 25th August 2003, and the Jharkhand Bihar Building Lease Rent Act was repealed.
There is the private party.
Yes.
There is nobody
No,
responding.
notice it has to go, and The main illegality is that rent has been fixed beyond 25%. As per section 8, more than 25% rent cannot be fixed. And the area of land has also been not taken care of, because if your petition will see paragraph 14 of my petition, there is deviation in the land. The land is only 2160 square feet, but the rent has been fixed for 2725 square feet. Paragraph 14 will be seen. And in paragraph 23, I have categorically mentioned that rent against 400 rupees rent, 11,625 rent has been fixed. Therefore, notice has to go melon, subject to your ladyship's. There are similar two cases in which notice has been.
What are those cases?
One I am not remembering, but
Passed by the same party?
yes, parties are different, but they are in same premises. One I will give.
Discuss status ticket to WPC 762 of 2019.
पेंडिंग में 24 सितंबर 2024 को नोटिस हुआ सर 2010
Okay, WPC number 746 of 2019. Heard the learned counsel for the petitioner. The learned counsel for the petitioner has submitted that improved order and action is contrary to the provision of that. He has also submitted that with regard to the same premises, another petition being WPC number 762 of 2019 has been filed. He submits that this case in which notice has been issued on 24th of September 2024. He submits that this case be tagged along with the same.
One more case I will give you the number.
He has referred to another petition. उसमें भी notice हुआ? With petition being WPC number dash. Same day notice हुआ.
I do not remember.
And submits that in that case also notice has been issued. Order provide कर देंगे यहाँ पर हम लोग डाल देंगे. Issue notice to the respondents under speed post as well as already process, for which recusals must be filed by Monday. Post this case. First, let this matter be tagged along with WPC number 762 of 2019 and record number. Second week January. क्योंकि अभी सर्विस रिपोर्ट आते हैं ऑफिस टू ट्रैक स्पीड पोस्ट डिलीवरी एंड प्रिपेयर एप्रोप्रिएट ऑफिस नोट इन कनेक्शन विद सर्विस ऑफ नोटिस. 9 January. Respondent तो सेम ही होंगे सब में.
Item 7, WPC 3673 of 2019.
Last indulgence is required in this case. Earlier there was direction to the circle official Gamaria to comply the order and to remain physically present. But due to election duty, he could not be physically present. We have received one letter from the deputy commissioner who is busy in conducting elections.
इसलिए ना करना पड़ता है क्योंकि आप लोग अपियर नहीं हो. हाँ?
Inadvertently.
आप इलेक्शन ड्यूटी में चल रहे हैं क्या? Why don't you appear?
On each and every date I had appeared, but on that date, mistakenly that could not be marked, that's why even regularly we have written letter to the
WPC नंबर कब आएंगे बताइए?
that may be
एफिडेविट कब फाइल करेंगे आप?
first week of December, since on 23rd election is going to over.
WPC number 3673 of 2019. Learning Council for the parties are present. Council further states amidst that he has received a communication from the Deputy Commissioner, Sarikela Kharsawa, stating that on account of election, the circle officer is not in a position to appear before this court physically. He has also submitted that some time may be granted to comply the order, and the matter be posted on 3rd of December. 3rd December.
It may be kept in second week of December, so that the order will be
10th of December. Let the matter be posted on 10th of December. The circle officer shall remain present on that. And the order passed earlier, we also complied. A copy of the letter dated 8/11/2024 as produced by the respondents is kept on.
Item 8, WPC 3823 of 2019.
Annexure 10 at page 141 is under challenge.
ये डिटेल है वो आउटलेट वाला तो ऑर्डर अभी तक किए नहीं है. एक पैकेट था ना
MDG मार्केटिंग डिसिप्लिनरी
वो तो अभी नहीं हुआ ऑर्डर. ये भी वही है.
नहीं ये डिफरेंट है. ये cancellation and the cancellation he had applied for allotment. However, since he did not submit the original document, which was a term under the application, his candidature was rejected, which he has challenged.
बताइए क्या बात है?
Millards. At page 141. With respect to the land in question, which I was supposed to provide, the original documents, the original sale deed, I could not produce, although I produced the certified copy, because original was lost. Here my case is, in case of I am not able to produce primary evidence, I was able to produce secondary evidence.
Lost deed से नहीं चलता है. आप कहीं mortgage कर दिए होंगे हुनोस. ये सब कहानी नहीं चलता.
इसीलिए तो
प्राइमरी एविडेंस सेकेंडरी एविडेंस ये कोर्ट में चलता है. दैट विल नॉट बी एक्सेप्टेड. आपने कभी न्यूज़पेपर पब्लिकेशन कराया दैट इट हैज बीन लॉस्ट?
I must kindly have page 143. Page
नहीं चलेगा, नहीं चलेगा. आपको बता दे रहे हैं straight away. The original deed can be mortgaged by delivery, right?
Therefore, I saw one document, one page 143. The last page of my brief.
Yes.
Here in noting part, the circle officer writes, it is in my possession, it is my land.
It doesn't make any difference. Even if you mortgage it, you will remain in possession. Mortgage से कोई disposes थोड़ी हो जाता.
Mortgage करेंगे?
नहीं करेंगे मतलब.
अगर mortgage मैंने किया होता तो जो mortgagee है वो तो possession में होता.
नहीं mortgage से possession transfer नहीं होता.
It is only on default and then
ये नहीं चलेगा.
Most importantly, the third party interest was created in 2019 itself. This matter has become infructuous.
Already created?
already created. It was given in 2019. The successful applicant was given the dealership and he is operating since 2019. This is covered when judgment of the Honorable Supreme Court, where the Honorable Supreme Court has said that in similar matter, if you don't challenge it for 4 or 5 years.
थर्ड पार्टी तो उसमें है भी नहीं यहाँ पे कैंसिलेशन के लिए.
जब हम फाइल किए थे तो उसमें नहीं allotment नहीं हुआ.
WPC number 3823 of 2019. For the learned counsel for the parties, this petition has been filed for the following relief. The learned counsel for the petitioner submits that the petitioner had participated in the matter of allocation of retail outlet dealership, but instead of filing the original deed in connection with the property offered, he filed a certified. Correct?
Milords, after being successful, Milords, at the field verification, I had to show original document.
That's right. This is what he filed a certified copy, due to which his candidature has been rejected. The learned counsel has referred to Annexure 11 to the petition to submit that the circle officer has certified that the property belongs to the petitioner and that the petitioner is in possession of the same. And under such circumstances, the candidature of the petitioner could not have been rejected. The learned counsel for the respondents has opposed the prayer and has submitted on 2 grounds. Firstly, by stating that the submission of certified copy is not sufficient, as the original copy can never be a substitute of the certified copy can never be a substitute of the certified copy of the original copy. He has submitted that in absence of the original copy, it is not possible to verify as to whether any right through equitable mortgage has been created in connection with the property. He has further submitted that otherwise also the present case has become infructuous, as the retail outlet has already been allotted to a third party who is not even a party before this proceedings. He has submitted that the needful was done to the next in line way back in the year 2019 itself. After hearing the learned
I have
counsel.
an additional solution. At para 7.8 of my counter onwards, you are given the entire terms and conditions which categorically said that you have to give originals. In fact, there was his undertaking given by him in his application that I have all the originals.
The learned counsel has also submitted that as per the terms and conditions annexed along with the counter affidavit, the original were required to be submitted, and at the time of participating, the petitioner had mentioned that he is in possession of all the original documents and shall submit the same as and when required. After hearing the learned counsel for the parties and considering the aforesaid facts and circumstances, this court is of the view that Annexure 7 to the petition was not sufficient compliance of the terms and conditions and the undertaking given by the petitioner with regard to possession of the original documents. This court also finds that the retail outlet having been allotted to a third party who is not even a party, who has not been made party before this court, no relief can be granted to the petitioner. Accordingly, this petition is hereby dismissed.
Item 9, WPL 4002 of 2019.
It is an ex-party order passed by the presiding official in which under section 28, 1 of the Source and Establishment Act, the 16,000 of the area amount along with compensation of 16,000 passed against in favor of the respondent number 1 and 2. Respondent number 2.
Why ex parte?
I have
Because
because in fact not the preliminary objection to be raised by me, that there is a statutory appeal provided against that order. If Lordship may kindly see note, what is section 28 subsection 7 of the Bihar, earlier it is Bihar Sub-Establishment Act, now it is Jharkhand Sub-Establishment Act. The order under section 28(1) has been challenged. Now if your Lordship may kindly see subsection 7. And read with rule 24.
Under 28.
7, subsection 7.
Yes.
it is either dismissing when the
no.
application is dismissed.
An appeal against an order dismissing either wholly or in part an application made under subsection or against a direction made under subsection 2 and subsection 3. So the direction was given for payment. So that direction is also inclusive in both cases. If it is dismissed or direction is made. Direction under subsection 2, where an application under subsection 1 is entertained, prescribed authority shall hear the application in the prescribed manner and may without prejudice to any other penalty, other penalty to which an employer is liable under this act, direct the refund of the amount deducted or payment. That is my case is that my payment has been deducted and not withheld. Therefore, that order was passed with compensation. Now, in Lordship mechanism, rule 24. Rule 24. Because in the prescribed manner, the subsection says about the prescribed manner. Now, it has been prescribed in Rule 24. Shops and Establishment Rule 1955.
Before the industrial tribunal?
Yes. An appeal under subsection 7 of section 28 shall be preferred within 30 days of the date on which the direction was made. Direction was made.
Before the industrial
Before the industrial tribunal. In case of Ranchi Minot, then your Lordship will find industrial tribunal Chotnagpur. In the cases relating to Chotnagpur division. Others are the Rohit Patna.
It is from
Devghar, so it is
Raipur division.
division or an officer authorized in this behalf by
May one thing. Let me verify this fact. Let it be after 1 week, so that I can verify.
Who is the state?
It is an ex parte order also.
Find it out.
Yes.
Where is the appellate?
Appellate tribunal. That.
Direct counsel for the parties are present. Counsel for the respondent, private respondent, has opposed the prayer by submitting that this petition may not be entertained as the impugned order is an appealable order. He submits that the impugned order has been passed under section 28 within bracket Roman 1 of Jharkhand Shops and Establishment Act and refers to subsection 7 thereof and also rule 24 of Jharkhand Shops and Establishment Rules 2001. Counsel for the petition seeks adjournment to examine the objection with regard to alternative remedy. Counsel for the state is also directed to seek instructions and inform this court regarding the alternative remedy as pointed out by the private respondent. Holds this case on next Tuesday?
Next Tuesday, but there is marriage in my family. Next to next Tuesday.
Next Tuesday,
Yes.
in the supplementary list.
Yes.
Item 10, WC 4150 of 2019.
Leadership, I seek time in this on behalf of senior counsel as he had Bhumi Pujan today. I had informed state.
Who is the counsel?
I had informed Additional Advocate General Ashutosh Anand sir was previously appearing in this matter, so I had informed him in the
No, who will argue for the petition?
Mr. R.N. Sai senior. He has Bhumi Pujan in his house, so he had requested. Private respondents are
Counsel for
not.
the parties are present. Private respondent, who is for the private respondent?
Ladyship, by last order, the office was directed to communicate soft copy to Mr. Priyaranjan Bhagat sir in this matter, as appearance was not there on part of private respondents.
Learned counsel for the petitioner seeks adjournment on the ground of the personal difficulty of the counsel for the petitioner. Close this case on 9th of January.
Item 11 WBC 4702 of 2019.
WPC number 4702 of 2019.
There is
Withdraw of this application and the liberty will kindly be given to prefer the NLP. If this is an applicable.
UC case, the GC, they have prayed that in UC case a decision should be taken. We have taken decision. Now they want to file an appeal before the king.
For that, against that. That's WPC number 4702 of 2019. Counsel for the parties are present. Counsel for the respondents has submitted that the case has become infructuous as final order has already been passed.
And my lord, we have an exit also.
UC case number?
UC case number 7 of 2018.
7 of 2018 on?
And we have that is on 14/10/2024.
On 14/10/24, correct?
Yes. Now the annexure.
Counsel for the petitioner seeks permission to withdraw the state petition and submits that liberty be reserved with the petitioner to take steps in connection with the order passed by the respondents. To this, counsel for the respondents has no objection. Considering the submissions, this petition is dismissed as withdrawn. Liberty is reserved with the petitioner to take appropriate steps in connection with the order which has been passed by the respondents.
Another order we have also annexed in annexure A of our contract. Signed.
Annexure A to the contract. 14/10 का order है ना? 14/10.
Item 12 WPA 5248 of 2019.
Yes, petitioner.
Order on a challenge is annexure 6 at page 28.
Can you read it?
My lord, page 28. Subject: industrial dispute over alleged illegal and arbitrary dismissal of Sri Sumanchal Swain, minor loader, personal and residential by the management of the Tributary under the of Mr. Sir, I am directed to refer to the failure of conciliation report dated 7th of May 2019 from the ALC number received in the ministry on 15th of May 2019 on the above mentioned subject, and to say that prima facie the ministry does not consider this dispute fit for adjudication for the following reasons. Sri Simanchal Swain, the concerned workman, minor loader, was absent from his duties with effect from 1st of February 2000. The workman was dismissed by order dated 5th December 2005, whereas the dispute has been raised by the union on 6th of March 2018 after more than 12 years. It is not reasonable to raise the dispute after so long period. As per section 2 capital A of the ID Act, the industrial dispute can be raised within 3 years from the date of dismissal of the workman. But in this case, Sri Simanchal Swain was dismissed on 5th of December 2015, whereas the dispute 2005, whereas the dispute.
Yes, what is the illegality in this case?
Legality, my lord, in the year 2012, the management has issued a circular to the person who were dismissed for absenteeism and worked in the company for more than 3 years, they will be reinstated. My lord, kindly have a look to Annex 2.
Did you place it before them? Did you place it before them?
That is their circular, man. That is their circular. Page
Ministry
22.
of Government of India?
BCC.
No, this order has been passed by Government of India,
Yes.
Bharat Sarkar,
Yes.
right?
Yes.
So, did you place that circular before that order?
Those materials were before the Assistant Labour Commissioner, and my lord, Assistant Labour Commissioner filed my lord, a failure report, conciliation officer, who is the conciliation of Assistant Labour Commissioner is the conciliation officer. He filed a my lord failure report.
What did you want? You were raising the dispute regarding legality of your dismissal, or you wanted reinstatement? What was your relief? Suppose the persons who have remained unauthorized absent and they have been dismissed. There are two causes of actions. One is that you challenge the order of dismissal. Other is that subsequently there is a circular and you want to be reinstated. What was the nature of dispute raised before ALC?
Annex 3.
Let us see.
Annex 3. Annex 3.
Yes, kindly read it.
Page 24. Illegal and arbitral dismiss. This should have been.
You are challenging the dismissal on merits.
Yes.
So it is not your case that you want reinstatement pursuant to some circular.
If the dismissal order goes.
You say that there is a circular that those people who have been dismissed on account of unauthorized absence, they are going to be taken in service, provided they have put in 3 years of service. Right? This is not your relief.
No. If the dismissal order goes, my lord, thereafter, my lord, the management will, my lord, bound to, my lord, reinstate.
No, therefore, the relief regarding order of dismissal has nothing to do with that circular. If the dismissal order goes, then by all means they have no option but to reinstate.
Very well, my lord. Now, my lord, the ground, my lord, by which the, my lord, reference has been, my lord, refused is, my lord, it is delayed, my lord, belated. And my lord, there are judgments, my lord, on the ground of delay, my lord, reference cannot be, my lord, refused. My lord, I am referring.
Which judgment?
Yes, my lord, I am referring an order of this honorable court, my lord. Of course, my lord, in this order, my lord, the ground, my lord, given that it is not reasonable to raise the dispute after so long period as per section 2 capital A of the ID Act. My lord, this dispute is not under section 2 capital A of the ID Act. This dispute was raised under section 10 of the Industrial Disputes Act. And my lord, in view of Nedungari Bank, my lord, the reference cannot be taken.
So you can seek reference anytime.
Not any time, my lord, whether dispute exists or is apprehended, that is to be seen. My lord, this Nedungari Bank was, my lord, considered in this order. That is, my lord, at paragraph 16. Paragraph 16. I read it? This court is of considered view that in the judgment passed by the Honorable Supreme Court reported in 2015, Volume 15, SCC 1. This is my Lord Prabhakar versus Joint Director, 2015. Numerous judgments have been considered, including judgment reported in 2000, Volume 2, SCC 455, Redungadi Bank. And it has been held in paragraph 28 that the law of limitation does not apply to proceedings under Industrial Disputes Act, and the word at any time used in section 10 would support that there is no period of limitation in making the order of reference. But at the same time, the appropriate government has to keep in mind as to whether the dispute is still existing or live dispute and has not become a state claim. If that is so, the reference can be refused. It has also been held that the point as to whether a dispute is alive or it has become stale at the time when the workman approaches the appropriate government is an aspect which would depend upon the facts and circumstances of each case, and there cannot be any hard and fast rule regarding the time for making the order of reference.
Yes, madam, in the improved order, has he referred? Has he stated that the dispute does not exist anymore?
No, he has, my lord, in this matter, that the judgment relied upon.
You forget about the judgment. There is no legal impediment in referring the dispute at a later stage. What is important is to be seen as to whether the dispute exists or not. Right? It can exist for a longer period, it can exist for a shorter period. It would depend upon the facts and circumstances of each case. Is it mentioned in the improved order that the dispute does not exist?
It is not reasonable to raise a dispute.
No. Whether it is reasonable or unreasonable is another thing. It is another thing to say that the dispute itself does not exist. Let us assume for a moment, suppose a person is dismissed. He goes and joins some other job, right, and works for 2 years. And then he is again dismissed in that organization. Can he raise an industrial dispute? Because dispute would not exist, right? The length of the period is not relevant. What is relevant is whether the dispute is existing or not. This authority, they are exercising some power. Have they mentioned whether that the dispute itself is not existing,
No, they have
and
said
therefore it's a stale claim, and therefore it should not be there?
No, they have mentioned that 12 years from the date of dismissal, it is a belated claim and dispute. And as per the Nanungadi Bank, जिसमें 7 साल का delay था, and the dismissal was there.
Period may not be relevant. What is relevant is that the dispute should not be existing.
The highly belated claim they have stated, which is a highly belated case. This has been mentioned. And the judgment that was referred by the advocate for the petition, in that there was 2 other grounds also for which the petition was allowed. First was, he raised a claim that the order for the dismissal was never served upon him. So that was a matter of dispute that was to be taken into consideration. Secondly, because the petitioner, the workman had died, expired, so there was also a relief associated with the dependents, that whether he can get the compassionate appointment or not. So because that existing claim was still there, so that writ petition was allowed, that even if it is a belated, but there was a matter of dispute that whether the order of dismissal was served upon the petitioner or not. And secondly, the rights of the legal heirs were also to be considered, because that was the reference that was.
No, I just want to know, is it required in an order refusing to refer the dispute that the dispute has become stale, or not? It is not reasonable to raise a dispute after 12 years. Can it be a ground for?
It is a highly belated case, that is a ground. The ground that has been taken.
Is it not required to be written that it is a highly belated case and therefore the industrial dispute does not exist?
Maybe words are different, but depending on.
We will not read anything into it. The reference has been used only on the ground that it is a belated case.
12 years, more than 12 years have passed, 2005, and there is no ground taken by the petitioner here that the order was never served upon him, or there is some other associated grievances of the petitioner that has to be looked into. My lord, a circular has been relied upon of 2012, 2005 का dismissal है, 2012 का एक circular आया, and that is not even the part of the reference as my lord has pointed out. और उस reference वो जो letter है उसमें भी लिखा है कि if the application is filed within that period, then only it can be reopened. Even that is not the case of the petitioner that I had filed an application that has not.
You have got the judgment of Newgati Bank?
हाँ, yes, I
know. Newgati Bank.
Para 6 and 7.
Here the reference was already made and the reference was under challenge.
Yes.
Para 7 जरा पढ़ी.
In the present appeal, it is not the case of the respondent that the disciplinary proceedings which resulted in the dismissal were in any way illegal or there was even any irregularity. He availed his remedy of appeal under the rule governing his conditions of service. It could not be said that in the circumstances an industrial dispute did not arise or was even apprehended after a lapse of about 7 years of the dismissal of the respondent. When a workman raises some dispute, it does not become an industrial dispute, and an appropriate government cannot in mechanical fashion make the reference to the alleged dispute, terming it as an industrial dispute. The central government lacked power to make reference both on the ground of delay in invoking the power under section 10 of the Act and there being no industrial dispute existing or even apprehended. The purpose of reference is to keep the industrial peace in the establishment. The present reference is destructive to the industrial peace and defeats the very object of the purpose of the Act. The bank was justified in thus moving the High Court seeking an order to quash the reference in question. It was submitted by the respondent that once the reference has been made under section 10 of the Act, a labour court has to decide the same and the High Court in which jurisdiction cannot interfere in the proceedings of the labour court. That it is not correct proposition of history. Ladyship, there is also a judgment, I have just one copy, which Ladyship has relied upon in that judgment as well. That is 2015-15 SEC 1, relevant para would be 12, 42, 44 and 45 I have written on the top, I do not have the copy.
42, 44. For the learned counsel for the parties. The learned counsel for the petitioner has submitted that by the improved order, the dispute regarding dismissal of the concerned workman has been refused to be deferred for adjudication by Labour Court. New reference. He has submitted that mere delay cannot be a ground to refuse reference. He has relied upon judgment passed by this court in WPL number 5260 of 2019, dated 13th of March 2024. The learned counsel appearing on behalf of the respondents has opposed the prayer and has submitted that after 12 years, the dispute was sought to be raised, and there was no explanation for such delay. She has submitted that she has relied upon judgments passed by Honorable Supreme Court reported in bracket 2020, yes, bracket 2000, bracket close to SCC 455, para 6 and 7, and judgment reported in bracket 2015, bracket close 15, SCC 1, para 12, 42, 44, and 45. That is all.
Litigation on that judgment does not cover this
And
matter
she has also
because
submitted that the judgment passed in WPL number 5260 of 2019 does not apply to the facts of the present case, as in the same judgment the dispute which was sought to be referred was regarding grant of compassionate appointment.
and also that the letter, the termination letter was never served upon the petitioner. That was
And that the termination letter was never served upon the deceased father of the applicant. Post this case for further hearing the applicant. इसे लिखा देंगे, भूल जाते हैं, थोड़ा सा देखना पड़ेगा एक बार.
petition with this judgment, the plaintiff should have marked all the points in the case. Have highlighted.
हम और एक जजमेंट हम साइड कर रहे हैं आफ्टर नेगुमरी बैंक 2001 वॉल्यूम 6 SCC पेज 222. I'm getting the photo.
2000 इन्हीं के में लिखिएगा ना, 2001 वॉल्यूम
6 SCC
6 SCC.
In this case, Negumari Bank has been considered and there was delay of 17 years.
The learned, in response, the learned counsel for the petitioner has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2001 volume 6 SCC 222. Para number?
Paragraph 9. 8, 9, 13.
Para 8, 9 and 13 to submit that in the said case.
13 and 15.
13 and 15 to submit that in the said case the delay was about 17 years.
15 years.
About 15 years. He has further submitted that the length of delay will not decide as to whether the dispute was existing or not. यही है आपका? Further hearing the applicant.
Item 13, the LPL 3063 of 2020.
Maybe.
The last occasion the management is appearing not. They have also preferred it application. It was dismissed. Perhaps they have filed a CMP for dismissal because the both cases were clear. I have filed for modification of the award, not awardment in my favor, not, but the only compensation has been given for that writ application has been filed for all retired leave because retrenchment was found illegal. Now they have also filed a writ application challenging their work. Last order now kindly have a look at 18th September 2024. Yes, so
18th September.
yes, 2024. Kindly have a look.
18th September 2024.
20.
What happened in restoration? Has been restored.
That's it. We do not have instructions right now. We have to seek instruction. Actually, Arvind Council was present in the morning, but due to some personal difficulties, he has left the court.
So when do you want to argue the case?
Any date may be given except today.
Except
Today.
day after tomorrow. इसका स्टेटस बताइए तो WPL 4216 और 2021 रेस्टोर हुआ है.
Whether they have filed or not.
CMP file हुआ है.
Learned counsel for the parties are present. Counsel for the respondents to adjournment. 9th January.
Item 14 WPC 4269 of 2020.
Claim for personal ownership cases also. Personal will be discussed.
What is your case?
It would be please Lordship. If your Lordship will kindly take the order dated 24th of July 2024. Your Lordship, this order has not been complied in its true spirit, Your Lordship. If I may place it. The present writ petition is with regard to the refund of e-stamp which has stated to be lost. It appears that the stamp has been purchased for a particular purpose, but due to loss of stamp, another stamp has been purchased and thereafter transaction has been conducted. The impugned letter
They
suggests
have filed an affidavit saying that e-stamp if lost, it cannot be refunded.
what is the process with regard to the refund in cases of lost stamp papers. But the affidavit which they have filed is exactly same which was filed earlier, the counter which was filed earlier. Even the paragraph is same, Your Lordship.
No, they say that as per the provision of stamp manual, respondent is not bound to refund the amount of misplaced e-stamp paper to the petitioner.
Your Lordship, but the provision which is there, it only deals with spoiled or useless stamps of the purchase of the purchase of stamps which is not required. It nowhere deals with the situation where the stamp paper is lost.
So if the stamp paper is lost, how can you get refund?
Your Lordship,
Just tell us. You think of a demand draft, right? Demand draft spoiled, some tempered, whatever, anything has happened. You go to the bank, they will refund you the amount. If the demand draft is lost, then?
Your Lordship, but we have lodged an FIR. They have verified the status of the stamp paper also, and we have also annexed the judgment of the Delhi High Court, in which a similar situation was there. Exactly same situation was there, in which the stamp paper was lost, and the court ultimately decided that it has to be refunded because it will come under the word obliterated. That the stamp has become obliterated, and hence it has to be.
And who will mark it as obliterated?
The court interpreted that the word which obliterated, which is used in the act, the lost stamp paper would also come under the same word, obliterated.
What is
And
the meaning of obliterated?
Unfit for use.
So
once a stamp paper is lost,
how does it become unfit for use? Does it have an expiry date?
Your Lordship, but it is in my name.
Does it have an expiry date?
No, Your Lordship.
कौन है आपके सीनियर जो बहस करेंगे?
Mr. Ashok Yadav, senior is
Does it have an expiry date?
It does not have an expiry date, but Milots had put a question to my friend that if a demand draft is lost, what is the
We
procedure?
were just trying to draw a parallel.
No, I'm just trying to
Forget about
clarify. In that event, what happens is that a person who has drawn the draft has to make an application to the bank. The demand draft which has been drawn has a number that is blocked, and the moment it is blocked,
So therefore, I want to know.
Same situation is here.
No, this stamp is to be blocked.
Yes, it has been blocked.
It has
that has
been
been
blocked,
done.
Lordship.
That has already been done.
Annexure 4.
Now that's what
And
happens.
it cannot be utilized
It cannot
by
be
anybody.
used for the reason. Minutes every stamp.
What is the method of using e-stamp paper?
Minutes.
Do you draw a document?
Yes, yes. That is what if Milots would
And
see.
suppose the e-stamp is blocked, but still somebody draws some
It
document.
cannot be.
It can't be done.
It cannot be. Because now, let's post 2013, if Milots are aware, Tilgi case, what is happening?
I'm
here-
not aware.
Well, may put it this way. Now, every stamp paper is generated by the bank from the online portal. I have to deposit the money either to the SIDBI or to the notarized agency, who will, after verification that the purpose, the Aadhaar card and the deposit is in terms of a document, agreement, then a stamp paper is generated. The stamp paper, earlier it was a notarized paper. Now it is a single leaf, which is drawn online.
And after its use or at the time of its use, is it uploaded or informed?
Yes, it has to be, because everything is mentioned in the stamp paper, that for which Aadhaar card it is generated, for which purpose it is generated, whose name is there.
After its execution,
Yes.
is it to be uploaded?
Yet it has to be uploaded. Otherwise,
Where do you say so? You have
that-
to produce the provisions. You see, they are absolutely clueless. Whatever we write, they will not be able to come to these kind of intricacies.
Now
right?
that is precisely the reason, Milots. Over
So you
here is the situation. I have tried to explain in my petition that after a document is generated online, Milots, there is a specific number to that document. Now, when the registration is carried out, that particular number is fed to the registering authority, who tallies that if the money has been actually deposited in the government treasury or not. The moment it is tallied, then the document is registered by the registering authority. The moment we say that we lost it, we registered an FIR and we wrote to the nodal agency from whom we had procured it, they gave us that we have blocked it because it was on our application, that we have lost it. So the moment we make an
So
application,
that stamp paper will not be used for any kind of registration.
Absolutely not.
For preparing an unregistered document can be used.
That it also cannot be used because there is a number, there is a unique code which is given. So if registered document, it is not mentioned that it is for a particular amount. Unregistered document is never for any amount. It is for 100 rupees, 500 rupees, 1000 rupees. Now over here is a situation. If Milo turns to page 51 for a moment, page 51 minutes.
Yes.
Now this is the document. If Milots would see, the certificate number is mentioned, the certificate issue date, reference, everything is mentioned. Unique code document reference is mentioned. Now this is the document when the registration is carried out, then at that point of time, this number is fed with the registering authority. And on the top, if Milot would see e-stamp verified certificate, the status of this certificate is not locked. This is a base certificate. So the moment the department says that no, this cannot be, this has been not locked, means
This is suppose somebody goes and buys e-stamp. This is the only page he will get?
Yes, madam.
Or there is more something
No,
else?
this is the only document which he get, and the Milot's original document, if you can just show.
And then he will make the
Milot's
make
question
the
is,
deed. In which document?
Milot's page 16 is the reply. Milot.
page 16 is the reply. This is the only page which is released by the nodal agency. And there is, everything is mentioned, even the stamp duty amount at the bottom, if my lord would see, it is mentioned. Now,
what is Article 23 conveys?
Article conveyance of registration of a real estate property, residential flat minutes. And after this document, I am just drawing an example, the next page, the recitals are mentioned. So the first page has to
all
be
blank.
Yes. And what happens is when the registration is carried out, the page numbers are also counted. And it is mentioned in the registration document that this registered deed contains so many pages, starting from this, ending at this.
Prior to this e-stamp method,
it was non-judicial stamp papers.
Right. Was there any provision for refund of no? Unless the original was produced, there was no question.
There was no
It is
question.
as good as losing cash.
Absolutely.
Stamp
in
papers
order to
were as good as cash.
Absolutely. And in order to curb out the cash issue, this provision has been brought
There
in.
is a judgment. I don't
Well, it's annexure 8 if my
no, that judgment of Supreme Court you were there.
well, it's Telgi case, well, the citation is not with me. I'll just give the citation.
It must have been referred in Delhi High Court.
No, Delhi High Court has not dealt with that issue. But Delhi High Court has interpreted as to what would happen if a e-stamp has been lost, because the court has taken a view that what cannot be done directly cannot be done indirectly. And if the money is lying with the state government and it is of no use to the state government, knowing it well that the e-stamp has been lost, for the same article you cannot charge twice. And that is the view that has been taken by Delhi High Court. Interpreting, if my lords would see, paragraph 30.
Suppose the e-stamp is lost.
Yes, ma'am.
Or remains unutilized.
Yes, ma'am.
Parties do not execute the deed at all.
Yes, ma'am.
You get the full refund.
It has to be, because it has to be cancelled. It has to be cancelled.
And you get the full refund.
Yes, that is what has been done in this case as well. That has
So
been
for
done.
the purposes of cancellation, you don't need any documentation. You have to simply go to the site and get it cancelled.
No, look, I have to deposit the original original stamp paper.
Why do you need to deposit?
Because
Suppose
until and unless I do it, unless I do it, if it is with me, assuming I procure a document for the purpose of registration, I do not execute it. Now it is lying unused. I want to cancel it. I have to make an application to the nodal agency. Now it is banks or other agency who issues it. So I have to make an application along with the original paper that this was issued. I do not want to use it. Please lock it and please refund me the money. So they'll carry out the verification from the registration department that if at all the replica also has been used or not used, because it's a printout. It's a printout.
Is there any such law that after how many till when such stamp can be utilized?
Well, we have not worked out on that issue.
Is there any such law that after executing the document, till when it can be presented for registration?
We'll have to check it.
There could be.
We'll check
that
it.
If
We'll
you
assist
prepare a
on-
document, you place it for registration after 3 years.
We'll assist my lords in this issue. Both the issues will assist. There's no difficulty.
Because I don't think that there is any such time limit to that.
No, sir, I could not get through in terms of registration act or the stamp act. I could not find any such.
Rahul
But
is there, he will help. Mr. Rahul, is there any provision that after the signing of the document or after preparing a document on e-stamp paper, after how many, within how much time it has to be presented for registration?
There's no time limit for registration, but Your Lordship, I was just trying to find out one judgment which said that period of 6 months is for refund of the
No, we are not talking
stamp.
about that. You see, stamp is lost. Now the point is that there is no expiry date on stamp. And once it is lost, it has not been utilized so far. Right? Is it possible that the document is prepared on that e-stamp paper, but it is presented for registration after 3 years? There is no legal
Section
bar.
48 of Registration Act says, but that
There is no time limit fixed for
Getting it
purpose
registered.
of yes, yes.
There is no time limit fixed for getting it registered.
For refund, there is a time limit, but all those
So
are
therefore, on a document which has been issued, e-stamp having been issued, suppose a person draws something on that, okay, but he does not get it registered for 3 years, then what will happen?
That's in that event, it is as good as it is used because it cannot be presented for. It has not been presented for registration.
It is used, but still used,
Still
not
used.
presented for registration.
Correct, Malak.
Fair enough.
Now over here is a case which
No, we are not on this phase. We are just trying to find out the modalities, right? Then what is the consequence of that document? The document is just a document which says that yes, e-stamp was generated, utilized, but not presented for registration. So that will be a document, an unregistered document to be utilized for collateral purposes, and in fact it can be utilized even for a part performance.
Correct.
Suppose the person is already put in possession, then it can still be utilized. Correct. Right? So therefore, that particular e-stamp if you want to be cancelled, then under such circumstances, how it can be refunded to you?
no, in that event, what has to be done is
Figure it out.
Yes,
This is what I'm saying. There
I will
are so
assist on
many
this
queries.
issue. I will assist on this issue.
Yes,
I will
please.
assist.
Right, on these, all these nuances are required to be taken
Absolutely,
care of.
absolutely. Because this will have a larger impact. So I think I should be fair enough to assist properly.
आप समझ गए? मिस्टर अशोक यादव को जी को बोलेंगे, थोड़ा YouTube देखेंगे और समझ जाएंगे कि हम क्या क्या बोल रहे हैं, है ना? ये देखिए एक केस का बात नहीं है. It has large ramification. We will not simply follow one high court. Supreme Court होता तो बात दूसरी. We will not. We will examine all these pros and cons while deciding it. And of course, the judgment of the Delhi High Court will also be considered. We will see. E-stamp issuance का कोई rules है? वो भी check करें. Learned counsel for the parties are present. Counsel, the matter relates to refund relating to refund of e-stamp which has been lost. During the course of argument, the parties could not show any provision of law by which the e-stamp would have stood expired, or if used and not registered, it can still be shown in the portal to have been used. During the course of argument, it has been submitted by the counsel for the petitioner that if a deed is prepared on the e-stamp and presented for registration, it is for the registering authority to verify it from the portal and confirm the payment.
The genuineness of the document.
The genuineness of document and confirm the payment.
Yes.
And also whether it has been earlier utilized.
Yes.
So 9 January to finish. Post on 9th of January.
Much. But the interesting issue has to be worked out a little.
सारे pros and cons लेकर आएंगे.
Yes.
Item password case item 1, WPL 1771 of 2009.
Yes, petitioner.
But my senior was here, he just left margin of fault in DB honorable DB.
You see, you can't have it like this. You also get prepared.
The day after tomorrow, I'll get prepared early in this month.
Learned counsel for the parties are present. The matter was prepared, was passed over as the senior, as the arguing counsel mistaken us, was on legs in another court. when the case is called up again, it has been submitted that he had to appear before division bench and therefore he has left the courtroom. Counsel for the respondents, she adjournment. She submits that the matter be posted day after tomorrow, and if her senior is not available to argue the case, she will argue the case. Post day after tomorrow at 2 p.m.
Household case item 2, the RPC 2381 of 2021.
In this case note, I have prepared a source synopsis note for argument. Source permit may file.
You see, in para 17 itself you are saying that there is an error. How do we resolve such an error?
Error.
Para 17 of the
Read petition. That due to error on the part of the respondent authorities, an error that is the contention of the petitioner. Number, admittedly there had been no acquisition of land. Admittedly, I will show from the records of the case that it is a rayati land acquired by the petitioner and his father and the other 2 petitioners. There are 4 petitioners in number, 5 petitioners in number. But I have, in support of my claim, I have annexed the documents.
You see, your prayer is that you are seeking a direction restraining the respondents from disposition.
Now, my lord, now, since in the meantime, there had been an interim order also, and there was a direction by your lordship also to state what portion of the land has been they have constructed building. I cannot say, my lord, that those should be demolished. Only prayer now, and for that purpose, that I should get the compensation.
You see, they might say that they are not interested, you take the property.
They do not say so. I will just show from the counter. On the other hand, they say that we have already constructed a Glebba school. Now, Lord, my question to myself, Lord, your lordship will find that that is the date of synopsis I have given you. On 30th April 1980.
You have been dispossessed from the property.
That part.
Certainly. That part, whatever be the part.
The 6.29 acres. Now, Lord, I want, Lord, compensation for this in respect of that property. Because it is during the pendency.
Has it come that it is your property?
Yes, I will just.
They admit that it is your property.
I will show to you, lordship.
Where is the admission?
Yes, I will just show from that. Let me
Documents
just
में
explain.
दिखाइएगा, affidavit में दिखाइए.
Lordship, may
That it is an admitted fact that on your property they have constructed.
Yes, your lordship, just see for a moment. For that purpose, I was referring the documents. Only I will take hardly 3 or 4 minutes, not more than that. Lordship, may kindly see in 1983, by registered sale deed annexure 1, page 41, the father of the petition number 1, he purchased an area of 6.75 acre in plot number 664. The another document annexure 4/31/1985, by registered sale deeds, the petition number 1 purchased 6.84 acres of land of plot number 664. And after purchase, their names were mutated in respect of the said land in question in 1986. That I have also given the details along with the correction slip and mutation order. That is supported by annexure 6 and annexure 26 at page 15 of the reply to the counter dated 16/6/2023. Rent receipts have been paid. Rent has been paid right from 1986 till date. Then, my lord, your lordship will find out there was a survey, and on the survey authorities also decided in my favor, declaring the entry of the name of the petitioner in the record of right, prepared by under the provisions of the Chutnagpur Tenancy Act. Then, your lordship may kindly see, proposal was made, annexure B, page 33 of the counter affidavit dated 10/12/2021. There are so many counter affidavits, therefore I have put the date also. On 28/5/2019, a proceeding was initiated by the circle officer Barwadi on the perusal of the proposal for construction of Eklavya Ashram School and call for a report from the circle inspector. And 12/6/2019, Annexure B, page 33-34 of the Contempt. Circle officer recommended for handing over 3.98 acres of plot number such and such and 8.78 acre of plot number such and such, total 5 acres. Calculation of the area of 3 plots are wrong. Then Lord, on 6/8/2019, subdivisional officer come LRTC Latehar, Lord, page 35 of the counter affidavit, recommended for transfer of that 15.08 acres of land to welfare department free of cost. Then very important document is not page 37 counter affidavit, 21/8/2019, Deputy Commissioner Latehar Millard approved the proposal of the LRDC by letter number 676 dated 21/8/2019, where I can demonstrate from that record, from the proposal, that only the 6.229 acres of land.
See, we will not enter into such kind of detailing
Your
of
Lordship, can you see
a
the-
property dispute.
No,
You
no
have
dispute,
it
no
is
dispute.
there are
Admittedly, without any acquisition. Your Lordship, can
Show
you see-
me one statement in their counter affidavit that the school has been constructed on
They
your
did-
property.
They did not deny the fact, Your Lordship,
No.
can you see it has been settled by the Honorable Supreme Court. That is the reason. Your Lordship may just see for a moment what has been decided by the Honorable Supreme Court. But Your Lordship observes, Your Lordship, just I will place reliance upon this judgment. Only a few paragraphs. Your Lordship, just see. Respondent, Your Lordship, just see, Lord. Appellant, now almost 80 years old, was undisputably owner of the land at measuring 3.34 acres in Khatan such and such. Respondent state took over the land of the appellant in 1967 for the construction of a major district road being such and such. The construction of the road such and such. High Court passed the similar persons approached the High Court in another case. The petitioner of this Honorable Supreme Court, he did not approach. Then Your Lordship, just see what has been observed by the Honorable Supreme Court. Your Lordship, may kindly come to para 10. Para 10. At page 5. We have heard learned counsel for the parties and perused the record. The appellant was forcibly expropriated of her property in 1967. Approached before the Honorable Supreme Court in 2020. When the right to property was a fundamental right guaranteed by Article 31 in Part 3 of the Constitution. Article 31 guaranteed the right to private property, which could not be deprived without the due process of law. And upon just
these are on a different set of facts.
This is the same set
You
of.
tell us from the record.
I'll
Then
just-
what is the description of your property?
Yes.
Where is the rent receipt?
Yes.
And then tell us from the record.
Mutation order, rent
You
receipt,
forget
and the
about-
document.
No,
I'll say.
why is this statement made that an error was committed? What kind of error is this? What
Because
step have you
error
taken
means-
to rectify the error?
No error in record. Error by acquiring my land without compensation. Your
No,
Lordship,
no,
just
no.
see para 17.
Para 17, read
Yes,
it.
yes. Your Lordship may permitted to.
You read para 17.
Yes, due to the error on the part of the respondent authorities, an area of 6.09 was recorded in the name of Muhammad Siddiq, and the father of the petition number 1 and 4.50, that is acres of land, was recorded in the name of petition number 1. That error in respect of area.
What is
I am not saying that the area. It is in the street. It is read in between the lines. The Lordship will find the record of right was prepared in the name of the petition
No,
number
I
1.
don't know what is this error about.
Error about the area.
How is it error
No,
about the
see,
area?
just see.
3.75 plus 2.34 is exactly 6.09.
Yes.
So-
Error may not be because we not para 18 Your Lordship mechanism.
Read para 18.
Yes. Muhammad Siddiq died on 20th May 2009, leaving behind the petition number 1 as his only legal heir, and all his interests
कहाँ
revolved
से
upon
अभी से पढ़ते?
That is the error. That is
Which
the
error?
error.
Where is
It
that?
is in continuous. Para 18, para 17 के बाद ही. That Muhammad, it was recorded erroneously in the name of my deceased father. That is the contention.
You read para 18.
Yes, Muhammad Siddiqui died on 20/5/2009, leaving behind the petition number 1 as his only legal heir, and all his interests devolved upon the petitioner. The petitioner became the absolute title holder of the land purchased by the father of the petitioner as such. The entire land, 10.59 acres, comprised such and such, and it came in exclusive
It
possession.
is exactly the same. The addition is the same. 6.09 plus 4.50
Yes,
is 10.59.
that was an error in the name of Muhammad Siddiqui, the dead person. This in the recent survey, and that has been corrected. I will just show you another document. The Lordship Miller rightly picked up para 17, but it is supplemented by other paragraphs. This is the error. It does not say that it belongs to the state. It does not belong to me. The error was the entry of my father's name, who already died, and not inclusive of my name. Then your Lordship may kindly see, my Lord, the petitioner is in uninterrupted exclusive possession. Then, my Lord,
You have acquired entire property through selling.
Yes, registered sale deeds. I have annexed. I will just show from the
Entire property. But
there are four.
what is it that you are talking about settlement also?
Yes, sir. There are five petitioners. There are 5 petitioners.
पांचों का कहानी एक साथ मिला दीजिए.
नहीं, अलग-अलग
फिर क्या?
करते हैं. रीट में ही अलग-अलग है.
रीट में अलग-अलग ऐसे होता है?
नहीं, ऐसा ही होता है. जो रजिस्ट्री लैंड है सबका, तो पांचों जॉइंटली किए हैं.
भाई, somebody is claiming through registered sale. Somebody is claiming through settlement.
That is also we have purchased the Lordship just see only bear with me only few minutes. Lordship just see paragraph I have, that is the reason.
आप एक-एक petitioner का कहानी सुनाइए. हम आपका एक साथ इस तरह से
petitioner का
basket में नहीं सुन सकते हैं.
उसी में एक petitioner का लिखे. एक petitioner का
And
लिखे.
first tell us what is the location of the house, this school?
Barwadi is the place.
Barwadi.
Barwadi.
What are the boundaries? Boundary of the school.
Boundary of the school has been constructed during the pendency.
Boundary of the school. What is the boundary of the school?
Yes, that is not the plot
Area,
number,
boundary.
number, area has been.
No, the plot number, khata number will not do. It is situated in part this plot, the area, the
that has
boundary.
come in the counter affidavit also. I will
Show me. I want to know from you.
First of all, I will satisfy your Lordship about the title of the.
टाइटल बाद में. पहले बताइए कि आपका जो ये जो स्कूल कंस्ट्रक्शन हुआ है, it is on the same property which you are claiming.
Yes.
Show it from us.
That is the reason I was referring, my Lord. Your Lordship just see, my Lord, the connection.
Where is it? Where is the area of the school?
Your Lordship may kindly see the Lord, para 37 of the counter affidavit. Enclosing there will be sanction of the defections.
You come para number 12.
12
of the counter affidavit.
Yes. There are so many counters. First counter.
10, 11, 21.
Yes, your Lordship just see,
10, 11, 21.
Para 12.
They say it's government land.
It does, readings are there, both parties, but your Lordship has to see
No, we will
which
not see.
pleading is supported
We will
by
not
which
see.
document.
No. We
Not
will
a
not see.
cheat
Your
of
title
paper.
suit nahi decide kare.
No, I have not done that. Prima facie, I will show from the records that if a person having purchased in 1981 continued to pay, getting mutation, I will also show the mutation order, correction slip, paying rent since 1981, whether he will be divested from his property, and that is the reason I was referring that judgment. A person, a lady approached after 75 years, and ultimately the SLP was allowed with cost of ₹1 lakh. By holding that such type of action on the part of the state is, they cannot say take the plea, it is barred by limitation or adverse possession or something.
They are
That
not
is-
seeking it, but they say that they have title over the property.
No, they cannot say.
Why?
Because
Why
your
can't they
Lordship
say?
has to.
Merely because they are state, they cannot say.
No.
Then?
They have to. I am showing the papers.
We are not here to examine the papers.
Papers which are prima facie show, and let them produce a sheet of paper that it property belongs to them. The mayor saying in the counter affidavit will not satisfy this honorable court that they are having the title. Whereas, on the contrary, I have brought on record several documents, unimpeachable documents, along with their admission by issuing rent receipt since 1981, by getting my name mutated. They are accepting rent. They have acknowledged me as a renter. Now, in one straight sentence, use in the counter affidavit that they are the title holder, that will be not suffice, not contrary to the documents which are on record. And your lordship has to see the pleadings of the parties supported by document and some bold statement, para 1, para 12, that is stated and submitted that in para 1, the prayer for writ petition and the reply is not maintainable as the land for construction of a club on 15.08 acres, a land comprised in RS Khata number such and such is government land. So this is the bold and serious statement. Let them produce a sheet of single paper showing that the land is a government Garmajurwa land. At the same time, your lordship may kindly see the inconsistent plea which they have taken. Your lordship may kindly see para 16. That it is stated and submitted that it is denied that the land was settled in favor of Rasa Bhuya, father of Moti Bhuya, by the ex-landlord Ramnaresh Prasad Singh, and no return filed by the ex-landlord. And as per the such and such land record available in the record of such and such, the CS Khatian, as per the survey Khatian land is Garmajurwa caste, and now the state of Jharkhand is the landlord. They are saying so. There are so many judgments of this on court. Lordship may kindly see para 18. The petition number 1 has purchased the said land of 3.75 acres from legal heirs of Moti Bhuya, Bajnath Bhuya and Kalesar Bhuya, Jago Devi. The registered sale deed dated 30th April 1983 bearing deed number Annexure 1 is hit by Chotnagpur Tenancy Act as the seller belongs from SC category. Now, in the shape of this statement, they want to challenge my right title interest and the sale deed of the year 1981 in the year 2021. After so many years, 40 years, and that too without filing a suit. That is the reason the division bench of this court held that mayor saying by a stroke of pen that will not observe the state government. If they claim it to be government land, they had to approach the civil court. That is the judgment of this court. Then your lordship may
Let them approach the civil court for declaration of the title.
Yes,
Whosoever is agreed will go.
No, I am not. I am agreed with the acquisition without acquisition,
Whosoever is
without
agreed,
following without taking recourse to law. They are using my land, and where the petitioner will go.
whosoever is agreed, whosoever claims right
No,
title.
I am agreed now, just now, because without admittedly I show from the record that your lordship just see page 19 also. They admit that petition number 1 has no right title possession over the no any signature of the authority has been obtained in mutation case number such and such 1983-84. I have brought on record by way of correction sheet and the order sheet also. Now they are disowning their orders passed in 1983.
Mutation will not create any right title.
I am not saying. I am not saying so. My title is there. That is not registered sale deed followed by possession,
You see, whatever
followed
be
by
the-
mutation.
Whatever be the plea based on, but they do not admit your title. At least
That admission will not be suffice not to deprive a person from his rightful possession and as a rear over the land in question. And sufficient and voluminous documents I have brought on record to substantiate my plea. Whereas, contrary to that, the state government, while making such bold plea that I have no right title interest, they are the government land, those are the government land, they did not bring on record a sheet of paper. On the contrary, I have been able to bring on record the unimpeachable documents before your lordship. And so far, the sale deeds which they attack on frivolous ground, that is their own opinion, and the court will not be bound by their opinion. These statements are nothing but bold statements.
some
Those are-
inspection was also conducted.
Yes, madam.
Some inspection was also
Yes,
conducted.
yes.
Inspection
Your
report is
lordship
in your
directed,
favor.
your lordship may kindly see one of the orders passed by your lordship now. First of all, the order number 5, 13/9/2022. An order was passed by the coordinate bench of this one report. Then this matter came to your lordship, also subsequently on 24/4/2023, order number 9. As you lordship got it, order number 9. IA number 2240/23 has been filed mentioning that in spite of order dated 26/9/22, the respondents continued with the construction and have violated the order passed by this court on 26/9/2022. there was an interim stay wherein an order was passed by the respondent number 7 shall not interfere with the possession of the petition number 1 with respect to the lands measuring an area of 6.68 acres. Learned counsel for the respondent submit that the construction work was being done through a contractor and therefore he shall seek instruction and file an affidavit to bring on record the necessary document to show as to whether any construction work has been undertaken even after receipt of a copy of this order dated 26/9. That is the order passed by us. Thereafter,
Then affidavit must have been filed.
Yes.
What is your stand in the affidavit?
Just seek the affidavit.
Yes,
आपको सुन लिया बिल्कुल सुन लिया. What is your affidavit?
Yes, Your Worship. We have categorically stated, Your Worship, that is
which count?
second supplementary count. IA number 2240 का apply करें, sir.
ये अमूल कोर्ट का ऑर्डर के बाद 24/23 के बाद
Second supplementary count, Your Worship, dated 24/4/23. May I read it?
24/4/23.
the order was passed on
Second supplementary affidavit.
Yes.
It is 12/5/23.
Sorry.
What is it?
Yes, yes, sir. May I refer page 4, para 6, Your Worship. The further statement submitted that allegation made by the petitioner number 1 of the instant petition that the construction work of the school is being carried out upon khata number 180 measuring to an area of 4.50 acre is totally false and fabricated. It pertinent to mention here that the land pertaining to khata number 180 has not been transferred for construction of a school, nor the contractor builder has constructed building over the said land. Next paragraph. It is further stated as submitted land pertaining to khata number 210 is गैर मंजूर वाला and the plots falling under khata number 210 being इतना so and so measuring an area of total 15 acre point 8 decimal has been used for construction.
Does this property belong to you in para number 7?
para 7.
Yes, para 7.
The land appertaining to khata number 210 is Garamajurwa land and the plots falling under khata number 210 being plot number 1421, 1422 and 1422 by 1510 measuring to an area of 15 acres 18.8 decimal has been used for construction of this school.
Is it your property?
Yes, yes, it includes my property. I will show to you. There is a reply to this. In note 8, para 8. Total 12 acres of land out of 15 acres of 8 decimal as mentioned above has been used by the contractor of the builder. It is still the petitioner never in possession. Now you will see may kindly see the reply to this.
And one more thing, Your Lordship. Permit just for a minute, Your Lordship. We have taken a categorical stand that this land, para 8 of the first counter, Your Lordship, and that is annexure A, Your Lordship, the record of right, which is the basis of even his plot, even any plot claimed by the state, Your Lordship, in the first counter affidavit. That is annexure A. This is the record of right, khata number, including in which the khata ka prakar is gair majrua khas, which belong to the government, and the plots mentioned here in the first counter affidavit, Your Lordship. All the plots which we have just referred, the rate that belong to this khata number 210, which is government land, Your Lordship. That and we have a specific claim that we have not entered into khata number 180. We are
This
on
is the
210.
plot. This is the plot where you have constructed
Yes,
the
Your
property.
Lordship. This is
And
yes.
according to you, this is government land.
Yes.
And he made an allegation that you are constructing in khata number
Yes.
180, which is not.
No, Your Lordship. So on 3 affidavits we have said this, Your Lordship.
बताइए sir.
Now, Your Lordship, if that is so, Your Lordship may kindly see for a moment. This property involved herein is RS plot number 1421, 1422, 1510 under RS khata number 210 in Moja Mangra in the This is not the property.
Your property involved is RS plot number 1421, 1422, 51, 1510 under Khata RS 210.
210. Yes. That is not earlier. It was Khata number 60. Now it is new Khata number 210.
No, I just 180. You just had mentioned that they were constructing in Khata number 180. That was your allegation. Para 6.
Of the writ petition.
No, of the affidavit itself. Of this counter affidavit. 12/5/23.
Second supplementary counter affidavit. In second supplementary counter affidavit, which you have also replied,
You see, we just इतना matching पुराना नया ऐसा नहीं हो सकता.
नहीं पुराना नया apparent है उसमें खाता नंबर
We
210.
are not here to match, mix and match.
Then I will just explain you.
नहीं उतना explanation नहीं हो सकता है. आपका वो सुप्रीम कोर्ट का judgment हम लोग consider करेंगे आपके साथ.
नहीं your lordship में
I consider that judgment.
I shall explain my lord the position.
We do not.
Now my lord your lordship में first of all they rely upon the recommendation of CEO.
We will not rely upon anything. You just tell us what is your case.
Yes, my case I have already stated, my lord, and I have this in the short notes also I explained that the RS plot number 1421, 1422 and 1510 under RS Khata number 210 in Moja Mangra is the land involved. Now, my lord, I have already, my lord, explained and supporting document I have already filed Annexure 1, 30th April.
You see, there are so many petitioners. Which property belongs to whom?
That is the reason I was just referring the notes, my lord, so that your lordship may appreciate.
We will not decide your title suit over here.
I am not.
Then why did you make an allegation that they are constructing in Khata number 180?
Yes, 180.
Para 6. The school is being constructed upon Khata number 180.
That is new Khata number 180 and new plot number 1422 under new Khata number 210.
कौन सा नया है कौन सा पुराना है ये सब
वही तो जो बोल रहा है ओल्ड खाता था 60 जिसमें प्लॉट हुआ 1416 1420 खाता नंबर 180 अब प्लॉट नंबर 1422 जो है खाता नंबर 210 बोल रहे हैं और उनका जो रिकॉर्ड ऑफ राइट दिखा रहे हैं उसमें भी वही दिखा हम एक भी एक्स्ट्रा नहीं लिखे एक चीज है जो कि इसमें टेबुलर फॉर्म में हम दे देंगे तो आपको
नहीं अब हम सुन लिए
आई हैव नॉट कंप्लीटेड स्टिल आई हैव टू से
आई हियर यू 215 का अब टेबुलर फॉर्म क्या ही देना
ठीक आज हम आगे नहीं आज कर कंप्लीट कर अब वो जजमेंट हो जाएगा
तो हम यहाँ पे नहीं डिसाइड
हम टाइटल सूट बोलेंगे भी नहीं जो उनका एडमिटेड डॉक्यूमेंट और सपोर्टिंग
डॉक्यूमेंट से नहीं चलेगा मिस्टर सानी प्लीडिंग से चलेगा आप कितना बार बोलते हैं एक ही बात आप लोग समझते ही नहीं
प्लीडिंग सपोर्टेड बाय
डॉक्यूमेंट में आप कुछ लगा देंगे अगर प्लीडिंग में नहीं होगा तो हम उसको नहीं मानेंगे
प्लीडिंग में और डॉक्यूमेंट में अगर वेरी करेगा तो देन आई हैव नो केस और अगर डॉक्यूमेंट और प्लीडिंग एक ही होगा देन आई हैव ए केस और उनका बोल्ड स्टेटमेंट विदाउट सपोर्टिंग एनी डॉक्यूमेंट इट कैन नॉट बी रिलायड डिवीजन बेंच भी कहा है सुप्रीम कोर्ट भी कहा है कि ये
आपका जो भी डिवीजन बेंच आप प्लेस नहीं किए हैं आप खाली ये सुप्रीम कोर्ट
और भी जजमेंट देंगे अभी हम लाए हम एक पॉइंट बोल के हम
कौन सा जज आप लोग लंच करिए हम तो पढ़ेंगे
लंच का एनक्रोच काहे कर मुझे का टाइम
नहीं आप लोग लंच करिए अब तो पढ़ेंगे तो सेकंड हाफ में सुनेंगे तो ऑर्डर करेंगे आपको क्या लग रहा है
असल में इतना वॉल्यूमिनस है
इतना भी वॉल्यूमिनस नहीं होता कोई चीज पढ़ने से खत्म हो ही जाता है चलिए इतना दिन से चल रहा है ना ये कहानी
नहीं तो हम भी चाहते हैं कि खत्म हो ज़्यादा दिन नहीं 2003 साल का इससे पुराना केस 2 साल
चलिए दीजिए कौन सा जज
एक और जज बाउंड्री वगैरह बना दिया इसमें बहुत सारा जजमेंट
डब्ल्यूपीसी जो है ना यहाँ पे जो है क्या बोलेंगे सब केस अननेसेसरी है यहाँ के लिए अभी तक सूट फाइल कर रहे होते तो डिसाइड हो जाता पोजीशन भी आपका हो जाता
एक रैयत जिसका रहती राइट 81 से है उसको आप बिना एक बार किए सरकार भी आजकल फ्रॉडुलेंट मेथड से एक लाइन लिख देंगे जीएम रिकॉर्ड में था सीएस रिकॉर्ड में इसलिए सरकारी जमीन
तो आप गलत जगह आ गए ना सूट में जाइए तो सब क्लियर होगा रीट पिटीशन में क्या ही होगा
रीट में ही डिसाइड हुआ है बहुत केस डिवीजन बेंच का जजमेंट है, सुप्रीम कोर्ट को फॉलो
ऐसा कोई जजमेंट है क्या कि टाइटल सूट में डिसाइड हो जाना चाहिए?
स्टेट विल गो टू टाइटल सूट।
देखिए एक सेकंड, हु विल गो इन टाइटल सूट? वी विल नॉट डिसाइड,
बिकॉज़ द स्टेट क्लेम्स
जिसका शू पिंच करेगा वो जाएगा टाइटल सूट।
उसमें हुआ है शू पिंच किया तो भी कहा कि स्टेट को जाना चाहिए, अदरवाइज स्टेट हैज नो राइट टू इंटरफेयर विद द प्राइवेट